In this lecture, we will discuss about Environment Protection Act 1986. So, the very introduction of Environment Protection Act which starts from the very Stockholm Conference of 1972, the International or the World Environment Conference relating to human environment was held in 1972 at Stockholm in Sweden, and the very conference led for the enactment of Environmental Protection Act throughout the world. Among the participant state parties and also those who are even not state parties to the Human Environment Conference at Stockholm in Sweden in 1972. And as India, one of the state parties to the World Environment Conference held at Stockholm, but after that, India, although enacted the Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981. And in spite of that, also India enshrined in its constitution provisions relating to environment protection as per the 42nd Constitutional Amendment Act of 1976, where India enshrined the very concept of environment and its protection in direct principle of state policy under Article 48 and also in fundamental duties, that is under Article 51A. Besides that, the constitutional document of India is already having the provision regarding Article 253 of the Constitution, which empowers the Parliament's legislative powers relating to any implementation of any provision of any international treaties or conventions. And also, we found that the Indian judiciary, the apex court, made it as a part of right to life and personal liberty under Article 21. In spite of these provisions, the Bhopal Gas Tragedy of 1984 necessitated the Union Parliament to enact the Environment Protection Act 1986. So, how under the 42nd Constitutional Amendment Act of 1976 it became a part of the Constitution of India as per the provisions under Article 41 of the directive principle of state policy, where it was exactly expressed that it was the state's responsibility to make efforts in order to protect and improve the environment and to safeguard the forest and wildlife of the country. While Article 51 of the fundamental duties expressly provided that each and every citizen of the country to protect and improve the natural environment, including the forests, lakes, rivers, and wildlife, and to have compassion for living creatures. And our judiciary, the apex court, which attempted in a number of landmark judgments on Article 21, which provides right to life, personal liberty, and right to live dignifiedly, which expressly provided why the apex judiciary in its landmark judgments that right to live in a healthy and safe environment is a part of the fundamental rights falling under Article 21 of the Constitution relating to right to life and personal liberty. And in the very important leading case, that is Subhas Kumar versus State of Bihar in 1991, the apex court held Article 21 as right to life with itself indirectly expresses that every citizen of this country also have the right to live in a healthy and safe environment, which was observed that the right to get pollution-free water and air is a fundamental right under Article 21. And as while Article 53 of the Indian Constitution empowers the Parliament to bring any legislation to give effect to any international treaty, agreement, convention, or decision taken at a conference. It was with the help of Article 253 of the Constitution of India, the Indian Parliament enacted the Environment Protection Act 1986 to give effect to the decisions taken at the United Nations Conference on the Human Environment, which was held in Stockholm in 1972. So, now we would like to discuss the very act under Section 2 provides the definitions relating to what is environment and what is environment pollution and what are the environment pollutants and what are hazardous substances. So, in that connection, we would like to define as per the provisions under Section 2 of the Act what is particularly environment. So, Section 2 of the Environment Protection Act 1986 defines environment, which includes air, water, and land, and in particularly it relates to hydrosphere, lithosphere, and also the particularly relating to biosphere and the interrelationship among and between air, water, land, and human beings or other living creatures, the microorganisms, plants, and property. And also it defined under Section 2 what is environment pollutant. A pollutant is any substance in a solid, liquid, or gaseous state which, when present in a certain concentration, can be injurious to environment and to the health of the people. And it also defines what exactly means by environment pollution. So, environment pollution means the presence of an environmental pollutant in the environment is called as environment pollution. It also defines regarding hazardous substance. So, as defined under Section 2 of the Act, it refers to any substance or preparation which can cause harm to humans, plants, other living creatures, property, or the environment due to its chemical or physiochemical properties or handling of such substances. So now we would like to discuss the provisions as provided under Section 3 of the Act. So as Section 3 provides the powers of the central government, so it provides that the central government has the power to take measures to protect and improvement through planning and execution of nationwide program laying down standards for the quality of environment, restricting all industrial operations and manufacturing processes, laying down the procedures for prevention of accident and to provide safeguards for handling hazardous substances causing environmental pollution. So, examination, investigation, research to problems of environmental pollution is also another power invested under to the central government in inspection of premises, plants, equipments, machinery, manufacturing, and other processes, and taking necessary steps to prevent and control of environmental pollution is another important power invested in the central government. Besides that, the central government or the Union Government of India has also been invested with the power of establishment and recognition of environmental laboratories and institutes, and also it is being engaged collection of information and preparation of manuals, codes, or guides to prevent environmental pollution, and in particularly Section 4 of the Act provides regarding central government's power to appoint certain officers. The central government, as per the provisions under Section 4, has the power to appoint officers for the purposes of this Act and to entrust them powers and authorities for prevention and control of environmental pollution. And as regarding Section 5 and Section 6 of the Act, the central government has the power to give directions and the power to make rules. To make rules by notification through official gazette regarding the following matters as the stand relating to the standards of quality of air, water, soil, and the very maximum allowable limits of various pollutants, including noise, and to provide rules of procedure for safeguarding and handling hazardous substances in different areas, also prohibiting and restricting hazardous substances, and also location of industries and carrying on any manufacturing process causing environmental pollution. And as per the provisions under Section 7, it has the power to prohibit persons and occupiers. So, to prohibit the persons and occupiers not to allow emission and discharge of environmental pollutants in excess of those standards laid down under the official gazette by the Union government, and as per the provisions under Section 10 of the Act, the central government also has the power laid down under Section 10 relating to power of entry and inspection. So the central government's power of entry and inspection of any industry, plant, examining and testing of any equipment, manufacturing process, record, register, documents, any other material objects. So also it could search of any such undertakings and could seize such equipment, industrial plant, record, register, documents and other material objects. Such industrial plants and persons shall assist in such work, and persons shall authorize it would be an offence under the Act. And now we would like to discuss the provisions as provided under Section 11 of the Act relating to power to take samples. So, it has provided the power to take samples of air, water, soil, or other substances from any factory, premises, or other places in the presence of the occupier or its agent or persons, and shall be kept in sealed container signed by both persons for analysis into the laboratories established or recognized by the central government. And Section 12 of the Act provides regarding establishment of laboratories. So, the environmental laboratories shall be established by official gazette by the central government or the Union Government of India. It also recognizes any other institutes as environmental laboratory, and it also to lay down procedures for analysis of samples of air, water, soil, and any other hazardous substances causing environmental pollution. And as well, Section 13 and 14 of the Act provides regarding appointment of analysts. So, it deals with government's analysts. The central government may appoint analysts through official gazette with such required qualification for the purpose of analysis of the samples of air, water, soil, and other hazardous substances in recognized and established environmental laboratory or any laboratory. Then the report of such analysis of those samples taken would be submitted to the central government, which may be used as evidence of the facts stated in such as in the legal proceedings under the Act. And as well, Section 15 of the Act, which provides the penalties, so in particularly describing the penalties for contravention of the provisions of the Act and the rules made under, and the orders and directions issued as according to the above provisions and rules. In cases of contravention, a person may be punished with imprisonment for a term of 5 years or with a fine which may extend to rupees 1 lakh or both, and in cases of failure to observe this said, a further fine of rupees 5,000 may be charged for every day of such violation if it further continues beyond a period of 1 year. After the date of contravention, the offender shall be punishable for a term which extends to 7 years. And as for the provisions under Section 16, which provide punishment for companies for violating the provisions and rules and orders and directions issued under Environment Protection Act 1986, which provides that any person in charge of any company did contravention of the provisions of this act shall be guilty of offences and shall be liable to be prosecuted against and punished. But under the exception, such could escape if a person established that the offence was committed without his knowledge or that he exercised due diligence to prevent the commission of such offence. Further, if such offence was committed with the consent or in the knowledge of any director, manager, secretary, or other officers of the company, shall be deemed to be guilty of such offence and shall be liable to be proceeded against and punished accordingly. Here a company means a body corporate which includes a firm or other association of individuals formed legally under the Companies Act 1956, which was renamed and amended in 2013 as the New Companies Act or the Partnership Act of 1932, or even other such acts. Regarding director of a firm means a partner in the firm. And as while regarding Section 17 of the Act, which provide punishment for government departments which committed such offences under Environment Protection Act 1986. So Section 17 provides that whenever or wherever any offence is committed, government departments, the head of the department shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. The exception is that such head of department shall have to prove that the offence was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offence. Further, any officer of the head of the department found that such offence was committed with his consent or in his knowledge shall deemed to be guilty and shall be liable to be proceeded against and punished accordingly. And now we would like to discuss the provisions relating to Section 25, which relates to power to make rules. So, central government's power to make rules regarding the standards of pollution, the procedure and manner in accordance, and the safeguards, analysis of samples, and the very forms and qualifications and comments laying down those standards and functions of the environment laboratories regarding which the central government has the exclusive power which it could make, and in connection to that, we would like to discuss one important relevant provision relating to Environment Protection Act, and that is Section 22 of the Act, which is most important, which relates to, in particularly, the bar on the courts to the taking offences under this act. So exactly section 22 is otherwise provides the bar of jurisdictions. So in regards to that, we found that section 22 takes away the jurisdiction of civil courts from entertaining any suit or proceeding related to anything done or direction issued by the central government or an officer or authority in order to discharge the functions assigned under this act. So now we have almost completed the relevant provisions relating to Environment Protection Act 1986, which was enacted by the Parliament of India only after the Bhopal Gas Tragedy of 1984. So now we would like to discuss certain important leading cases or landmark judgments relating to Environment Protection Act, and in that connection we would like to discuss the first important leading case, that is Vellore Citizens Welfare Forum versus Union of India, which was decided at the apex court in 1996, where the particular fact of the case is that river Palar is a river in the state of Tamil Nadu, which is also one of the main sources of drinking and bathing water for the surrounding people. The petition was filed against excessive pollution caused by tanneries and other industries in the state. The Tamil Nadu Agricultural University Research Center also revealed that a significant portion of agricultural land had turned either partially or completely unsuitable for cultivation. So the very issue in this important leading case, should the tanneries and industries be allowed to operate at the expense of damage to the surrounding environment. So the Honorable Court held that the court highlighted that the main purpose of the Environment Protection Act is to create an authority as under Section 3, subsection 3, with all the necessary powers and functions to protect and improve the environment. However, it was disappointing that not enough authorities were appointed for the same. Thus, it directed the central government to appoint an authority within 1 month and confer on it all the adequate powers required to deal with the situation created by the tanneries and other polluting industries in Tamil Nadu. It also directed the authority to implement the precautionary principle and polluter pays principles, which already we have discussed in our previous lectures, which are part of those principles developed by the Broadland Commission and which were adopted by the Stockholm Conference in 1972. A fund called Environment Protection Fund was also to be constituted as per the direction of the apex court. The compensation received was to be employed for reversing the damage done to the environment and to the victims of the damage. And two other most important leading cases that we would like to discuss. One is important as it is popularly known as Ganga pollution case, and it was filed by the renowned advocate and environmental activist MC Mehta. So it is known as MC Mehta versus Union of India, which was decided in 1988 by the apex court. So we would like to discuss that very important and popular and famous leading case decided by the apex court or the Honorable Supreme Court. That is the Ganga pollution case. So the very facts that we would like to discuss first, that Kanpur has been the hub of tannery business in India for a long time. Most of these industries are located on the southern bank of the river Ganges. These industries have been known to have contaminated the river. In 1985, a mastic tossed into the river resulted resulted in a massive fire in the river because of the presence of a toxic layer of chemicals formed on the surface. Thus, MC Mehta, a famous environmental advocate and activist, filed a petition in the Supreme Court against the tanneries and also the Municipal Corporation of Kanpur to stop them from discharging untreated effluents into the river, polluting it. So the issues involved in this important leading case is that whether the authorities had been negligent in protecting the river Ganges from pollution, and the second issue rests, should the similar industries be aided financially for the installation of treatment plants, and what standards should determine smaller industries. And the apex court held that there were several laws in force in India that sought to prevent environment pollution, including the Environment Protection Act 1986 and the Water Prevention and Control of Pollution Act 1974. However, the authorities had been negligent in discharging their duties prescribed under these laws. It also observed that the financial capabilities of industries are relevant when considering the issue of installing primary treatment plants. Thus, each tannery was directed to at least install primary treatment plants, if not secondary plants. The court also laid down the guidelines, so such guidelines as it was the duty of central government to direct all the educational institutions across India to teach lessons on environment protection and improvement at least for an hour every week. Also, the second guideline issued by the apex court, the central government must publish environment textbooks and distribute them among the students. And another important, popular and famous leading case also filed by advocate and environmental activist MC Mehta versus Union of India in 1991, and it is known as the vehicular pollution case. So in that particular case, the facts that we would like to discuss. Delhi is the national capital territory of India and it is included as one of the most polluted cities of the world. Over the years, the population of Delhi has become multi-fold and as one of the results of that, the pollution levels have been sky high. The main source of pollution has been the two-wheelers, thus MC Metro. The advocate and environmental activist filed the petition in the apex court to highlight the flight of the capital due to vehicular pollution and suggest practical solution to the problem. So the issues involved in this important leading case is that what steps should be taken to prevent and reduce vehicular pollution in the national capital territory of Delhi. And ultimately, the apex court, in its judgment, held that with reference to technological and other solutions suggested by the petitioner and the literature present, the court passed the following interim orders. So, it is the duty of the state under the directive principle of state policies and also as mentioned in section 51 of as a fundamental duty to protect the environment, life, flora and fauna. And the second most important guideline regarding the other is relating to that awareness is the key to reducing environmental pollution. People must be made aware of the harmful effect of vehicular pollution on environmental health. And finally, the third part of the order is relating that a committee was formed to look into vehicular pollution in the national capital territory of Delhi and suggest practical solution to prevent it. So, another important case that relates to environmental pollution is the oleum gas leak case of Delhi, which is related to the instant death of an advocate of the Hazardous court due to the leak of oleum gas from the Sram fertilizers factory in Delhi. And now we would like to conclude our discussion on the very important topic that is Environment Protection Act 1986. So, the very conclusion of the lecture where we would like to discuss that post the Stockholm Conference of 1972 and the oleum gas leak case. The concern for the environment has magnified the provisions of the Environment Protection Act 1986 mark a positive step towards environment protection and improvement. It has stipulated some stringent regulations for the prevention, control and abatement of environment pollution. The central government has been given a wide scope of powers to frame rules, regulations, and to appoint authorities to further the purpose of this Act. Additionally, the Act has facilitated the coming of several notifications of environmental protection which have introduced new protective principles like the environment impact assessment. It has also empowered the citizens to play a proactive role in environment protection by culling out the pollution causing industries. Under the Environment Protection Act of 1986, which has led to a string of environmentally sound judicial decisions. However, there are still some lacunas present in the act that need to be filled with subsequent amendments to update the act with changing times. So, we have completed our lecture on the very important piece of legislation enacted by the Indian Parliament, that is the Environment Protection Act 1986, which was enacted due to the Bhopal Gas Tragedy of 1984.